I'd like to start this afternoon to thank the traditional owners of this land. We respectfully acknowledge the traditional custodians of this land on which we are meeting, the Turrbal and Jagera peoples. It is a privilege to be standing on country. We pay our respects to their elders, past and present, grateful for their care and preservation of the land, sea and communities. We also acknowledge the contributions of Aboriginal Australians for their faithfulness and energy given to the life of the Christian Church in our country. We are delighted that we're opening this seminar series by Jonty, and she's graciously given an awful lot of her time and energy, and she is quite a master of dealing with us older people. And she puts out this marvellous newsletter, What's On for Seniors. So there's a number of these at the back of the church, and so please take one of those on the way out. She's a very, very active lady physically. She's a whirlwind of a runner, apparently, and she's, I understand, health has been not on the easy side for you for a little while. Is that right? Yeah. But we really do appreciate you coming here. She is our local member of the Cooper electorate, and she is your voice, our voice. And Jonty may be able to hang around for a little bit for morning tea. Is that a possibility, Jonty? Yeah, thank you for doing it. I know you're an incredibly busy lady, and we really do appreciate the time you're giving to us. So Jonty, would you like to come up and say a few words yourself?
Well, I am absolutely delighted to be joining you today on Jagera and Turrbal land. Thank you for the beautiful acknowledgement and welcome to be here. It's actually my complete privilege to be here. I was thrilled to be asked to kind of do a bit of an introduction, and before I do that, I'll do a bit of a preamble. But yes, I'm walking a bit poorly. I'm an ultra marathon runner, and I just did my first 100-kilometre run 2 weeks ago, so I'm still kind of feeling very sore after doing that. So if I'm walking around ouching, it's got nothing to do with the beautiful company that we have here today. Look, when I was asked to come along and to speak today and to say a few words, I kind of reflected on why today is important, and without taking away from our beautiful speaker, who I'll mention in a moment, when I was first elected to Parliament, a lot of people around me said it's really important, Jonty, that we engage young people in Parliament, and we've got to set up these youth groups and engage with young people and understand what their needs are and make sure they've got a voice at the table. And for the first couple of years, we did a lot of work in that space, talking to young people, of all types around what those needs were. And I guess over time and settling and sinking into the role a bit, what I notice is that actually most young people are very good at speaking up and speaking out. They know what their rights are, they know how to exercise their rights, they're digital natives operating in a highly digitised world. And yes, there's vulnerabilities and we have to be aware of that always. But I started to notice actually it's probably our older folk who are probably needing a greater seat at the table. And you've mentioned the seniors newsletter, and I'll talk about that. And I want to put a caveat around that by saying I don't even know how I feel about the word seniors. I have mixed feelings about that. It's kind of the government word, but I'm open to ideas of how we can re-reference that maybe in afternoon tea. But I really became aware that for people, once they retire, the world shifts a lot. And then as people get a bit older, they might start to lose friends and family. Their world changes a lot, and there's not a lot of help to navigate that. There's an assumption that we'll just all work that out. And then when people lose their licence, things change again. Trying to navigate bureaucratic systems that are now digital, very difficult. You can often walk away feeling like you made to feel a bit silly or that you're missing a conversation. So we pulled together a seniors advisory group, and one of the big things they told me is actually they want more access to information, and that's where we started to do the newsletter, to just put something out biannually so that people could have access to information about what's going on around them, so that they could stand up for themselves. They knew what services existed, they knew what their rights were, they were equipped with information of what was coming ahead, and they wanted to participate in community, and sometimes that was really difficult when they found out about events afterwards. So I'm thrilled to be here for a couple of reasons. One is it's great to see these events happening, and it's great to see people attending them, because that's really important. Two is because we don't often plan well enough for what's coming ahead, and I often say to people, I've had a really healthy, appreciation of ageing. I think birthdays and ageing is a gift that not everybody gets to have. And so I celebrate ageing, but we also want to have a good life as we age. And part of that is knowing, what's ahead and how do we plan for that. So I'm going to hang about because I want to learn some stuff from Craig as well. Craig's a wonderful speaker. I won't take Terry's the wind out of his sails. He's doing the proper introduction, but we will be learning a lot today, and I certainly will be taking a lot of notes and putting things into practice while I can as well, because it's never too early to start planning for things, that are coming along, so that we can have that security and have a good life as we all get older. So thank you for being here. I'm going to hang around if you want to have a yarn afterwards. Happy to hang around and have a chat. Thanks for including me, and I look forward to hearing what we've got to say.
Thank you. I'd like to introduce you to Craig Ray. Now, most of you probably know Craig Ray. He is... they were going to talk about renaming Settlement Road a short time ago, I understand, and they were going to call it Craig Ray's Passage. And let's all vote for that. Look, Craig is very well-known solicitor here, and he and his family are tremendously engaged in a lot of local kind of issues. So if you've got any real problems, go and see Craig. He's a magic man. Craig will be speaking for 30, 40 minutes, something like that. And after that, we're going to have tea and coffee in the hall. And then following that, we will come back, about 15 minutes for that. And then following that, we're going to have a Q&A time. So save up all those sticky questions, for Craig. He loves them. We will finish well before 4 o'clock to get you on your bicycles. Okay, so Craig, come and thrill us.
Thank you, Terry, and thank you, Jonty. I've got a fairly wide-ranging discussion that I need to cram into that 30 minutes, so I'll get underway. But initially, obviously, this is very much generic and high-level comments, and you need to obviously go and get your own independent advice, as your particular needs may differ from some of these general comments. Can I start off by saying that you don't have to have a will, and you don't have to have an enduring power of attorney. If you don't, though, what you're effectively doing is you're abdicating your will to external parties. So if you don't have an enduring power of attorney and you lose your capacity to make decisions, then you're going to be dependent on your family, and they will have to apply for a formal appointment through the Queensland Civil and Administration Tribunal. Now, that can result in people being appointed to manage your personal health affairs and your financial affairs, who may not be people that you would particularly want to do that job. And ultimately, we have in Queensland the Adult Guardian's Office, who will step in to manage personal and health affairs for individuals, and the Public Trustee, who will manage the financial affairs. And the same is also applicable in relation to dying intestate without a will. The Succession Act in this state provides a set of rules known as the intestacy rules, which deal with the way in which an estate will be managed in circumstances where there isn't a will. And sometimes people say if you die without a will, the money goes to the government or the Crown. Well, there is a small measure of truth in that. It passes through the intestacy rules, first of all, to your next of kin, which is spouse and children. If there are no spouse and children, then to remoter issues, such as brothers and sisters, nieces and nephews, aunts, uncles and cousins, and if there are no one left in that group, the Crown does end up with your estate. So, having had those introductory words, it's quite clear that it's important, I think, for you to determine what you want to happen. So I'm going to deal first of all with some documents which may assist in circumstances where you are alive but you have lost your capacity. So that's the enduring power of attorney. That document has essentially two parts. The first part is around the management of your personal and health affairs. So things like which hospital, what level of care, should you have the operation or not, which nursing home should you be placed in, and end-of-life decisions. The other part relates to the management of your financial affairs for your benefit. So most people typically would appoint their spouse, and then it would be wise to have a backup, and usually that's your children, because we can't tell what's going to happen in the future, and it's important to think not one step but 2 or 3 steps ahead, because if, for example, your spouse passes away and you lose your capacity, you can't update the document. So therefore having different levels of appointment is important to cover off. There is another document that gets mentioned quite regularly, and that's known as an Advanced Health Directive. Now, the Advanced Health Directive allows an individual to prescribe what they wish to happen in relation to their health management in the future. It needs to be completed with the aid of your general practitioner and needs to then have a declaration signed off by a solicitor, Commissioner of Declaration or Justice of the Peace. Now, advanced health directives only apply in a very narrow circumstance. And the narrow circumstance is defined under the Act to mean a circumstance where you are in the last 12 months of your life and that you are suffering from an incurable illness, and of course you don't have capacity. And by that document, you are saying to the medical providers, and for that matter your family and an appointed attorney under an enduring power of attorney, this is what I want to happen. Last year I gave a paper to an international conference of medicos, the Spark of Life conference in Melbourne, and I was surprised to see the reaction of the medical profession when they heard that they were actually bound by the terms of the Advanced Health Directive. Now, my view is, personally, I probably wouldn't have an Advanced Health Directive. And the reason why I say that is that there was a brand new nursing home built in Newcastle called New Haven. And in fact, there's a podcast on the in New South Wales, in Australia. And there's an ABC podcast on this. And what happened was that one afternoon, or as people came into the nursing home, typically they said, have you got an advanced health directive? And we're talking about people in their late 80s, early 90s. And most of the people then filled out an advanced health directive, and they typically said that they did not want to be resuscitated. Now, what happened in that particular circumstance was that a nurse went round one afternoon with some insulin, and she injected 4 of the individuals who were residing in that nursing home. They became hypoglycemic, and the first person became so unwell that they admitted them to the hospital. And they arrived at the hospital, Advanced Health Directive, don't resuscitate. So medicos said, right, don't resuscitate, call the family, this person will pass away. And they put them in a quiet room, and that was that. Around about 40 minutes later, a second ambulance arrived with a second patient, same condition. The registrar thought, this is a little bit suspicious, same nursing home, same conditions, called the consultant. The consultant said, look, I'll come in. When the consultant arrived, the third patient had arrived, and the consultant said, ring the police. Now, the hypoglycemic condition can be easily remedied, but we have advanced health directives saying, I do not want any treatment. So what happened in those cases was that the individual families had to apply to NCAT, which is the equivalent of our QCAT, Queensland Civil and Administration Tribunal, to get rulings to overturn the advanced health directives. By the time those rulings came through, the first person had passed away, sadly. The other 3 people were able to be revived without any adverse condition. The nurse is now sitting in jail, having been charged with and convicted of murder and 3 attempted murders. I am of the view that if you have an enduring power of attorney in place and you have responsible people who can make decisions, isn't it better for them to make the decision in circumstances where you can't, with all of the information at their hands? Okay, we might move on to then wills. Now, people, as I said, don't need a will, but the whole purpose of a will is to express your will, your expression of what you want to happen when you pass away. And these documents are designed not only to save time and money, but also to make sure that things go smoothly within a family. And when drawing a will, first of all, you need to decide who you wish to appoint to administer your estate. That's known as the executor and trustee or personal representative. And typically people appoint their spouse and then their family. The executor's function is very important. I mean, they have all of the responsibility in relation to finalising your affairs, so collecting your assets, identifying debts that may sit in your name, including, for example, taxation, and then once they have cleared those liabilities from your assets, distributing the estate in accordance with what's set out in your will. And most people use a fairly standard format of will whereby they leave everything to their spouse, then to their children. Again, thinking a little bit deeper, if something happened to one of your children, perhaps you need to give consideration to the next generation down as well. And that can be all incorporated in the will. Importantly, when drawing a will, you need to determine what assets sit within your name or your control and what things may pass through other means to family members. So, for example, often people, when they own a home as a couple, they'll hold it as joint tenants. They'll own a motor vehicle together. They'll own a joint bank account together. And those assets technically will pass to the survivor as opposed to going into the estate and being dealt with in accordance with the will. And that will become significant when I talk about challenges to wills a little bit later this afternoon. Superannuation, for example, also fits within that category. If property is held, however, as tenants in common, then your interest in that property will pass in accordance with the terms of your will. So it's a good idea to just double check how you're holding your property. And often people, when I ask that question, say, I can't remember, we do a title search and it'll come back either tenants in common or joint tenants, and that clears that issue up for them. And sometimes when we do those searches, we find out that there is still a mortgage on the title. So people pay off their mortgage, great, bank's done, but the formal release of the mortgage isn't done. So that's another thing that's worth checking, and it can be easily tidied up with your bank, and do it now because it's one less job that you're going to leave for your executor to attend to. Now, the will can also deal with your funeral arrangements. So you can express, for example, burial or cremation. Some people wish not to have a funeral. Some people wish not to have a religious ceremony. This is your opportunity to explain through the will what you want to happen. Now, wills can also incorporate a trust. Now, often people read in the paper about testamentary trusts. Testamentary trusts are certainly more complicated, but are put in place for a variety of important reasons. So the first reason they're put in place is to ensure that assets that pass through your estate are fed into the trust and therefore are protected. So, for example, you might have a child who might be a bankrupt. You might have a child who might be in a high-risk occupation whereby they might lose everything overnight, for example, a property developer. You might also have a child who's got a disability or may be subject to substance abuse, or potentially may have a relationship that you're not certain will endure. Therefore, you can use a trust to pay the assets into, not directly to the individual. The trust works by a mechanism of you appointing the people who will manage the trust, that's the trustees, and you name the beneficiaries. Now, testamentary trusts also potentially have some tax benefits, although this is now the subject of some debate, and we're yet to see how the federal government will manage the taxation of trusts moving forward. One hopes that the reasons that I've expressed before will hold sway with the government so they don't bring in that tax, because it's not just about spreading income, it's about protecting assets, protecting individual children with disabilities and those sorts of things. And the trust then receives the child's inheritance and it's managed by the trustees for the benefit of the trustees. So testamentary trusts are often a very useful vehicle. I now want to turn to superannuation, because superannuation sits outside your estate and you need to get very careful accounting and financial advice, because superannuation in Australia is the lowest tax environment that you can operate in. And certainly when you go into pension mode, you do not pay any tax, the super fund does not pay any tax on the income it earns. So it's important to try and keep as much money in superannuation as you can. And there is a device known as a reversionary pension, whereby if one spouse passes away, the surviving spouse can keep the majority of the deceased super in that environment. It's worth checking that out. The other thing about superannuation is that you can put in place what's known as a binding death nomination. And before I turn to that, I just want to explain that your superannuation will be managed by a superannuation fund. So we have things like the Australian Retirement Trust, Sun Super, MLC, those sorts of operators. And what happens is that a member who passes away and there is still a balance sitting in their account, that member's account has to be paid out by the super fund. And the super fund has the discretion as to where they may pay the member's benefit. The discretion's not terribly wide, but it requires attention, because they can pay it to your spouse, they can pay it to your children, including stepchildren, they can pay it to someone who is financially dependent on you at the time of your death, or they can pay it to your estate. Now, I have seen a super fund sadly take over 9 months to work through a process before releasing the funds. And of course, life goes on. The rates come in, the insurance bills come in, repair to the car, the hot water system blows up, and you're trying to run a family and you've lost your spouse and you're waiting around for a super fund to make a decision. So to get around that, you can put in place a binding death nomination, which says, for example, if I pass away, my superannuation benefit will be paid to my spouse. And then the super fund is bound by that, and the production of a death certificate, the money comes straight through to the spouse. So super is a very important thing to manage, because we have more and more of our assets sitting there. And one thing about super, of course, is that sometimes it has attached to it a death benefit. And sadly, about 5 years ago, I had, without disclosing confidences, some people come to see me and their child had passed away in a rafting accident. and the child was only 21. And they said, look, there's a small bank account and a car, there's no will, what do we do? And then I said, did your child work? And the answer was, well, they're at uni. Yeah, they did a bit of tutoring. So maybe we better get on to uni super and find out if there's super. Yes, there is uni super. Okay, is there a life policy attached to it? Yes, there is. $500,000, right? So I suppose the lesson in all of that is, once you turn 18, you should probably start to think about planning these things, because often they just get missed and then it becomes a much more difficult process to manage those things and collect the assets in. I want to touch on the concept of probate now quickly. Probate is an order of the Supreme Court, and its purpose, as the name implies, is to prove someone's will as their last valid will. Now, you do not need to obtain probate in every incident. You only need to apply for probate in circumstances where, first of all, the executors think to themselves, is this my parents' or the deceased's last will? Before they go marching off administering an estate and then finding out, hang on, there's a more recent will where they would have to then fold it all back in and start again. Now, most executors know when a will is the last will, because they've been informed by the testator, I've made a will, you've been appointed as my executor, this is where my will's located. The second reason people have to get probate is because a third party, for example, a nursing home, the Australian Stock Exchange or a bank, says because of the value of the asset in the estate, so a refundable accommodation deposit with a nursing home, these days $750,000 is not uncommon, says we won't release that money unless a probate order is produced, because the nursing home or the bank or the Australian Stock Exchange want to protect themselves against the risk of another will being produced. Probate basically takes around about 3 to 4 months to obtain, and it's a process that costs around about $2,500 to $3,000. We're very lucky in Queensland. In New South Wales, probate, the fee is based upon the value of the estate, so it's a hidden tax, whereas in Queensland we have a flat fee which is paid to the court. I also want to talk about taxation in this sense that I'm not an accountant and I'm not going to go into any great detail, but capital gains tax is potentially a hidden death duty, and it's something that probably needs to be managed through your estate planning. And again, that's where teamwork between a financial advisor and an accountant and a lawyer is very important, because sometimes you can end up, unfortunately, falling into a situation where tax is paid unnecessarily. Now, I want to talk about people contesting wills. Often you'll see this in the press, and it's important to understand this. Under the Succession Act in Queensland, there is a small group of people who can seek a provision from a deceased estate, and they are a spouse, a child, including a stepchild, someone who's financially dependent on the deceased at the time of their death. Now, anyone in those classes can apply to the court to ask the court to rewrite the will. Now, there are certain qualifications. They have to give a notice within 6 months of the date of death, and they have to bring the proceeding within 9 months. And the principle that the court has to apply under the legislation is this: what would the reasonable testator, the deceased, have done to make adequate provision for the claimant? That's the test that applies. So sometimes in estrangements, it's not unusual for family members to say, well, I don't want to leave anything to this child, or I want to leave $1,000 to them. That will not suffice, because if the estranged child says, no, inadequate provision has been made for me, they can make an application to the court to seek provision. Now, that can be very protracted, it can be very expensive. So the best way to manage it is make adequate provision for them. And if you're in a position where you think to yourself, well, no, I don't want to give them anything, then you should provide some assistance to your executor by providing a statement as to why you haven't made provision for them. Now, we normally prepare that in a form of an affidavit, which is a sworn document that can be produced to a court if necessary in the future. And a sworn affidavit can go into great detail. For example, I've reached out 40, 50 times to engage every time the door has been shut. Some terribly cruel circumstances arise in people's lives, and it's an opportunity for the deceased person to actually have a say before a judge in circumstances where they've passed away. So a family provision application is something that you need to consider and potentially guard against when preparing your estate plan. Terry, how am I going for time?
Another 10 minutes.
I've got another 10 minutes. Okay. Well, what else can I cover off on this? No. Thank you, Terry, for that. I guess that the other things that people often get concerned about is, for example, particular things they want to go to particular members of their family, and that can be dealt with through the will. You can be very specific with respect to family heirlooms and list them, or alternatively, you can actually manage it by way of referring to a list which is then deposited with your will, and you can update that from time to time. But that brings me to the process that often happens today. The reality of our society is that 2 generations ago, families were 6 and 9 children, and there wasn't much wealth. The reality today is that we often have only 1 or 2 children, and the wealth is quite substantial. And so, as part of the estate plan, sometimes people actually want to manage it by giving things away during their lifetime. And this is an important thing because we're living longer, that's a reality, and the other thing is that the needs of the next generation or the following generation are quite high. We know housing prices are quite exorbitant, and individuals' ability to save deposits is harder. So we hear often about the bank of mum and dad, and this is a circumstance where people often, as part of their estate plan, decide while they're alive to give things away to the next generation, and that can be quite useful. There is no such thing as gift duty in this nation, which is a great thing. So anything that an individual receives through that mechanism will be free of tax, and that's a big bonus to individuals. So that's part of a process when you're looking at an overall plan as what you need to do. Now, often situations arise where families want to make adjustments because they may have favoured one child because of need at a particular point in time, and they haven't topped the other child up during their lifetime, and so they want their will to operate as an equalising mechanism. And that can be achieved through the will. For example, you can disclose that a child might have received, say, $500,000 in 2026, and you can put a mechanism in the will that says that the other, if you've got 2 children, the other child will be topped up with that $500,000 at the time of your death. Often people also build into that a CPI provision so that it keeps up with inflation. As we know, all of our children have different needs at different times, and it's a mechanism to try and adjust for that. Really, I think I've covered off enough, fairly rapid fire. Time?
A little.
Good.
Look, there is an old truth out there, is that the seat can endure, only what the heart and the mind can withstand. And you've had a lot of mind stuff at the moment. So it's time for a coffee break. We're going to come back for Q&A. So give it about 15 minutes, but keep the conversation rolling over your cup of tea. Enjoy.